Good evening, you're watching No Spin. I'm Nidhi Razdan. Tonight, the confrontation between the government and the judiciary has escalated, with Law Minister Kirren Rijiju writing to the Chief Justice of India, saying that the Supreme Court Collegium, which decides on judges' appointments, should include government representatives as well. In the letter to Chief Justice D.Y. Chandrachud, the Law Minister has said that this will infuse transparency and public accountability. As news of the letter broke, Delhi Chief Minister and AAP convener Arvind Kejriwal tweeted calling it dangerous and saying that there should be absolutely no government interference in judicial appointments, while the Congress called it an attempt to intimidate and then capture the judiciary. But responding to Mr. Kejriwal's tweet, the Law Minister said that his letter was, as he put it, just the precise follow-up action suggested by the Supreme Court while striking down the National Judicial Appointment Commission, or the NJAC. That was the alternative that had been passed by Parliament to appoint judges and would have included a government appointee as well. Well, the Supreme Court scrapped that many years ago. But in recent weeks, there has been a stepped-up attack by the government on the system of appointing judges. And this has also been expressed very vocally by the Vice President of India at different platforms. The current system of appointments does not give the government any say in the process, but the government can and does hold up appointments for months on end by sitting on the files which are sent to them. The Supreme Court itself has stood firm so far on any government interference in the process. So is the Law Minister's letter, which has clearly escalated the matter, actually a call for transparency, or will it amount to government interference? Let me first welcome on the program tonight Justice A.K. Sikri, who is a former judge with the Supreme Court of India. Thank you very much, Justice Sikri, for joining us. I just wanted your thoughts first, on this entire controversy, sir. Do you believe that the Supreme Court must stand firm and resist any government interference in judicial appointments, or that the Law Minister makes a point that it needs to be more transparent and the only way to do that would be to have a government representative in the collegium?
I think let me start it from another perspective before coming to the answer to the question which you have put. Today, as the position stands, as you rightly mentioned, NJAC Act, which was passed, has been declared unconstitutional by the Supreme Court. So collegium system stands, and that is the law of the land. Of course, what government wants to do, and whether they want to bring another legislation or wants to make another constitutional amendments, etc., I need not go into that. I even need not go into the question whether the collegium system is the best system and there is no other alternative, etc. Having said so, one thing is very clear, which is being discussed at various levels. Those who are even justifying the collegium system, many of them have raised voices insofar as the functioning of the collegium system is concerned. Many are dubbing it as opaque or shows lack of transparency, etc. But the question is, as you have rightly said, in this entire context, whether this letter of the Law Minister and suggesting that there should be a person of the government as a part of collegium, whether it is going to serve any purpose or not. But before even going into this issue, I have another fundamental issue, which is this. You see, collegium system has been introduced not, by the Supreme Court, not on administrative side. Not that it is an administrative decision that this should be the collegium. It is in the form of judgments of the Supreme Court. As we know, these are called Judges Case 1, 2, and 3, by which it was introduced. And how the collegium, what it should comprise of, how it would function, what is the procedure, etc., all that is laid down. Now, once that system is determined by a judicial verdict, it would be, in the first instance, I would say that it would be difficult for Chief Justice to tinker with that judicial system on administrative side, unless it is done by modifying the earlier judgment and sitting again on judicial side. So therefore, as of now, as I said, in terms of the judgments of the Supreme Court, when it comes to the appointment of High Court judges, the first three judges of the High Court, they have to, Chief Justice and other two have to recommend. And
So,
then
what I'm asking is, do you believe there should be a government representative on the collegium? Yes or no? Do you believe
no,
that
what
would be
I'm
fair?
saying, the first I'm saying is that, I mean, the issue may not arise because unless there is a amendment to that order or modification of the order on judicial side, it is not even feasible or not even possible.
But in
That
theory,
is what I'm trying
do you
to
think
say.
theoretically that the government is correct to say there should be a government representative, or do you believe that even with all its faults, the collegium system is still it's better to keep it this way rather than have any government interference?
No, I tell you there, how it will work or how it will not work, only the time would tell if such a system is introduced. Theoretically speaking, I don't know when the justification which is sought to be given that it will bring transparency and public accountability. I'm not too sure with one member of the government, if he or she is included in the collegium, how it is going to bring transparency. What would be the role of that person? Because the collegium decides after shortlisting the candidates who should be appointed as judges of the High Court or who should be appointed as judges of the Supreme Court. So what would be the role of the government nominee in that collegium? Of course, once that decision is to be taken, and if he is it, now I'm theoretically saying what you have said, suppose it is possible by modifying the judgment and including it. So question is, we'll have to determine if he is the part of collegium, then he has a right he will have say in the decision making.
My question, sir, is on principle, should the government have any say in the appointment of judges?
No, on principle, as of now, actually, let me tell you, it's again a very vexed question, in the sense that there has been a lot of debates. Initially, as the constitution provisions stands, before these judgments in judges' case, it was the government had complete say in the matter. Of course, as of today, it's only the I mean, they can the government can only say or give its inputs to the candidates which are selected, whether they should be or there's something against them, IB, etc. Because as far as intelligence wing is concerned, this is not with the I mean, the courts have no role, or courts cannot go into that issue.
Sure,
but
I think at the heart of the matter is, and I'll just bring in the rest of the panel here, so do stay with us. And we'll also have Justice Madan Lokur joining us shortly, also former Supreme Court judge. Shadhan Farasat, advocate with the Supreme Court. Aman Lekhi, senior advocate of the Supreme Court, also joining us. Shadhan Farasat, the heart of this debate really is the collegium system itself, and whether it is transparent or not. I think even those who are currently in the judiciary agree that it's actually not the best system. It does require change, reform. The question is whether that should include any direct interference from the government at all. How do you see Kiren Rijiju's letter to the Chief Justice of India? Shadhan Farasat.
So first thing, I think the Law Minister's letter is bordering on inappropriate. I think, as Justice Sikri pointed out, there is already a decision. That decision clearly says what the collegium is. The collegium only comprises of the judges of the Supreme Court. If there is some aspect of MOP which has to be, memorandum of procedure which has to be finalized, that will certainly not include a new member being added, that to a secretary of the Government of India. So I think the Law Minister himself knows that his suggestion is not within the remit of the existing law. And if they had a problem, they could have filed a review against that judgment, and the Supreme Court will deal with it. As Justice Sikri rightly pointed out, this is not something which is done on the administrative side. There is a judicial decision of none less than a constitution bench as recently as 5 years back. So it can't be under, number one. Number two, will a secretary, home secretary or a law secretary present on that this thing add to transparency? I don't see how. Number three, which is very important, the Government of India is one of the biggest litigants in our top courts, be it the Supreme Court or the High Court. It is every day you will have matters where Government of India is one of the contesting parties. Therefore, in the Indian context specifically, more so than any other country, where you have the biggest litigant before the court, and the court has to be seen to be fair, having a major role in the appointment as opposed to a procedural role, which is what is envisaged under the collegium system, is obviously going to be problematic. And finally, we are all there for transparency. Yes, there are problems with the existing collegium system, but they can be corrected And I'm sure the existing collegium with the present Chief Justice will take appropriate measures. Some movement has been seen in the recent past, in the last 3-4 years. There has been a bit of to and fro on that in terms of giving out reasons, at least reasons which are not prejudicial to those whose application is being considered, which will not impact the reputation. Those aspects can certainly be brought in the public domain. But those can be done by the judiciary as part of a collegium. I don't see how a home secretary or a law secretary, apart from interfering in these decisions, is going to add to transparency.
Let me get Aman Lekhi on this. Mr. Aman Lekhi, what are your thoughts on the process as it stands today and this confrontation with the government now?
Well, you see, either you call it babble, lacking restraint, sense, reason, or you see it as part of a structured discourse meant to diminish the Supreme Court and present it as essentially an obstructor. In either case, it's noise. In one case, it's pointless. In the other case, it's sinister. And in either case, it doesn't lead to meaningful debate. The question which you put was, should the government be involved? What is missed is that the government is already involved because the process is interactive. It's not as if the judges appoint judges, as is being simplistically put, because there is involvement of the government in the appointment. And in fact, that's where the problem comes in. Where does the problem come in? There has to be a memorandum of procedure. Now, the memorandum of procedure was first made in 1999 and subsequently, pursuant to the third judge's case, it was eventually finalized in 2017. The memorandum of procedure sets out the age, the eligibility, the complaint mechanisms, secretariat. So that sets out the process of appointment. The problem is that there is no meeting of the government on the memorandum of procedure. The court says that the memorandum of procedure is in place. The government disagrees because of some observation in Karnan's case. Nevertheless, insofar as the appointment is concerned, the IB is involved, the state governments are involved, the central government is involved. And the problem here is not merely appointment by the judges, but the stages in the appointment, that is, in the forwarding of the names to the collegium in one case, or making appointments in terms of the collegium's recommendation in the other case. What the law minister does not in any way flag is the conduct of the government in either of these cases, and he is egregiously wrong in saying that he is acting in terms of the Supreme Court order, because the Supreme Court order, the third judge's case, struck the NGAC down. I mean, I have got my own reservation on the decision. Point is, that is a law. And that had a system of two nominees who are to be part of that particular committee, which is to appoint the judges. All that happened post that judgment was a decision, an order, requiring formulation of memorandum of procedure. Now, if the parties agree on the memorandum of procedure, the conditions relevant for the appointment would be as the memorandum of procedure stipulates, and that will bring in transparency as to the method of appointment.
But
it would have behoved the law minister to have
Mr.
actually...
Lekhi, what you said right at the beginning, that there seems to be, in a sense, what you're saying is that there is a sort of a structured way that an attempt is being made to diminish the Supreme Court. You use the word sinister. So are you saying that there is it's a sort of, I mean, you have the vice president who's been talking about this very openly, the law minister's, been in a confrontation with the judiciary. Are you saying that there is a sort of a larger plan at play here, which may eventually possibly result in the government pushing for a fresh law in Parliament on judicial appointments?
Well, the government is entitled to come with a fresh law. There is no bar in the government coming with the law. As far as the question as being sinister or not, that the question is moot. I see absolutely no reason for such comments. These comments are very frequent and have been made rather flippantly by responsible holders of constitutional posts. These are serious issues, have a long history, and have to be debated in a very serious manner. You cannot possibly play to the gallery while make comments and suggest that what you are saying is actually legally sanctioned when it is not. My problem is the way in which this particular debate is being structured. There is absolutely no issue in our reconsidering the method of appointment and devising a substitute to what exists. But you cannot, in the guise of substituting the system, attack those involved in it. And as far as judiciary is concerned, I feel it's a very important institution which deserves to be preserved and protected. And as far as judges are concerned, whatever may be the failing of the system, as far as judges are concerned, we need judges as they are for the purposes of upholding the values which we hold dear, so that our polity which is based on law remains protected. I am very against comments which become personal, which attack persons rather than deal with institutions or institutional issues.
All right, I want to get the Congress and the BJP in as well, because this has become a big political issue, and perhaps rightly so. But Karuna Gopal is here from the BJP. You've heard very senior, eminent jurists speaking here, Karuna Gopal, and Aman Lekhi's comments very strong there. Playing to the gallery that this is undermining the judiciary, the higher judiciary, in so many ways. How would you respond to that? Is this unnecessary needling by the government?
Well, Nidhi, your panel is skewed towards the judges. So what I see now is we have jumped to the 4 judges.
It's a bit unfair to say the word skewed. I mean, these are all eminent. One is a former Supreme Court judge. 2 of them are very eminent senior lawyers. So I think to attribute motives to them would be a little unfair.
No, I'm not attributing. I'm just telling you my perspective.
Sure.
I said we jumped straight to the 4 judges case where we are talking about the memorandum of procedures, which actually has not been touched by the collegium itself. So if we, perhaps take a macro perspective, come out and try to look at it from the democracy and the 3 pillars of democracy, then you would certainly see the birth of collegium itself was quite a bit of a pain, in the sense that it is not we saying it, but look at the first judge's case and the second judge's case in 1982 and 1993, where it has categorically been defined, the consultation has been kind of called as concurrence, and that gave a Hobson's choice to the executive in selecting the judiciary. Now, there is the reason why we have to pay close attention to this is that it is not we saying it from the political party, but there have been several judges and several CJIs who went on talking about judicial reforms, and especially the collegium system. And one perhaps which is quite striking as an outsider, I'm sure you would have also noticed in the year 2018 how 3 judges came out and spoke about what needs to be done, like Joseph
No, absolutely. I think most people agree that there needs to be greater transparency in judicial appointments, but is the answer to that giving the government a veto on appointments so directly? I mean, actually, Aman Lekhi is right. They're involved in the process in an indirect way, but the final say rests with the judiciary. Doesn't the government actually have a vested interest in being directly involved in this?
I was actually coming to that when I mentioned the 2018 occurrence, the public press meet, where, if you recall, the Attorney General, K.K. Venugopal, categorically said that the Supreme Court is becoming omnipotent at that time. And he said it cannot afford to become the 3rd chamber of the parliament. Now, perhaps he echoed what Jawaharlal Nehru also said. Jawaharlal Nehru also categorically said, so some of you have, maybe allegiance to the Congress. And he also agreed to that. So here, having some
couldn't resist sneaking that one in, but I'll let that pass. My question was completely different about whether the answer to judicial transparency lies in greater government involvement. Adil Boparai of the Congress would like to just make a comment, and then I'll just go across to Justice Madan Lokur after that. Yes, Adil Boparai, the Congress has also very strongly today accused the government of trying to, in a sense, take over the judiciary and silence it. Yet I'm sure you would agree that the collegium system currently is quite opaque and does need reform.
Well, Nidhi, the government's recommendation, and I say this with utmost sincerity and responsibility, the government's recommendation will mark the death knell of the independence of judiciary in this country. This is a government which wants complete subservience. This is not a government which wants transparency. This is a government which has captured every institution in this country, and perhaps that's why they're emboldened. That is why you have repeated assaults on the judiciary by individuals who are holding high constitutional positions. Can you be a judge in your own cause? The government of the day is the largest litigant. And it is completely misleading when the Law Minister and other functionaries say that the government is not involved in the process of appointment. Of course there is consultation. Of course the intelligence branch gives its inputs. There have been instances where the government has returned files for reconsideration. The Supreme Court Collegium has often deferred to those recommendations. It is only in the second round that the government of the day is obligated to clear those names. But please see, this is a pattern. And the pattern is that you want yes men. I repeat, you want yes men in positions of power in the judiciary. This is the objective. It's time, it's high time in this country that we pierce the wheel, we pierce the spiel of the BJP. It is not about accountability, it is not about transparency.
So you're saying it's about yes men everywhere, including in the courts. Let me just go across to Justice Madan Lokur as well, who joins us on the program this evening. Justice Lokur, thank you for being back with us, sir. I remember that when we've had a conversation on this subject in just weeks earlier, you expressed very clear apprehensions about the government's motives here. How do you see the Law Minister's letter to the Chief Justice today?
Yeah, well, first of all, thank you, Nidhi. What the Law Minister has said in his letter is not yet in the public domain. At least I don't have access to what he has said. So it's just a report which says that he wants.
Well, he confirmed it through a tweet today. He didn't, he didn't deny it, and he very much confirmed that it was a follow-up, as he put it. Yeah,
but it seems that at least that's what's come out, that he wants somebody to represent the government in the collegium. Now, in what manner does he want that representation? Is it somebody who's just going to sit on the sidelines of the collegium meeting and watch the proceedings? Or is he going to be somebody who's going to take an active part in the discussion? Or is it going to be somebody who's going to say yes or no, depending upon what is presented? What are the powers of that person going to be? Does that person have some kind of a veto right, in the sense that if the collegium says that, yes, we want to appoint somebody, and this person says no, will the government say, well, our representative has said no, so therefore we're not going to appoint that person? So we really don't know, what exactly he wants.
But how do you see this escalation? Or, it's been very steady. A number of comments from the Law Minister. Yeah. The Vice President has made comments as well at different forums, including Parliament. So, yes. Do you see it, as Aman Lekhi does, that there's a kind of a sustained, structured effort to diminish the Supreme Court, as he put it?
Yes, but there is definitely, some sort of an assault on the independence of the judiciary. Well, at least we are heading towards that assault on the independence of the judiciary. And, whatever has happened in the last couple of weeks is a clear indication of that. Where it's going to end, I don't know. And this is, again, one step, assuming the worst. This seems to be one step in that direction.
But Justice Lokur, I know you also would agree that the collegium system in its current form is not the best system. It is opaque. There are judges who themselves and lawyers, etc. So many people within the system have said that there are no essentially the complete lack of transparency in that system. How would you change it if you had to today to make it a better system?
Well, there are two things. One is a change in the collegium system within the Supreme Court, right? For example, you could have, why are you selecting a particular person? Is there some kind of a criteria, or is it, what was said at some point of time, you scratch my back, I scratch your back kind of system, which it is not, by the way. But what is the criteria on which you make a recommendation? So that's one aspect. Another aspect is what happens in the government is tremendous opacity within the government itself. Why are you rejecting a particular person and asking the Supreme Court to reconsider? What is the basis of that rejection? Why are you processing some cases in 2 days and processing others after 2 years? So it's at both levels that there has to be this transparency at both levels.
All right, Justice Madan Lokur, I'll leave it at that today. Thank you very much to you and to the rest of our panelists for joining us. Thank you to Justice Sikri, Aman Lekhi, Shadan Farasat, Karuna Gopal and Adil Boparai as well. We'll see you again tomorrow. Goodbye.